This is Duke University.
Thank you everyone for coming. My name is Andrew Hand. I'm the incoming editor-in-chief of the Duke Journal of Constitutional Law and Public Policy, and on behalf of the Journal, the Federalist Society, and the Program in Public Law, I would like to welcome you to our event today. With that, I'll turn it over to Professor Siegel. Thanks.
Well, thanks very much, and thanks to all you folks for coming today. So this discussion has something for everyone. Right? We've got dogs, we've got drugs, and we've got the Fourth Amendment. I mean, what more could you want? We're honored to have with us today two very distinguished speakers with a rich array of experiences. Professor Alicia Hilton is a law professor, poet, essayist, and author of creative nonfiction and fiction. Before practicing law and becoming a law professor, she was an FBI special agent. Right? So I used to pretend I was one as a kid, and she actually did it. As an FBI special agent, she was a member of a foreign counterintelligence squad and also worked undercover in 2 long-term criminal cases, posing as a drug dealer with ties to organized crime. She received her bachelor's degree in sociology from UC Berkeley, a master's degree in humanities from the University of Chicago, and her law degree from the University of Chicago. We're very pleased that she could be with us today. We also have with us Duke's own Professor Lisa Griffin, who writes and teaches in the areas of evidence, criminal procedure, and federal criminal justice policy. She joined Duke's faculty in 2008, received the 2011 Distinguished Teaching Award. She's a member of the American Law Institute and has testified before Congress on proposed revisions to the mail-in wire fraud statutes. She's a Stanford Law grad and clerked both for Judges Nelson and Justice O'Connor on the Supreme Court, has spent 5 years as a federal prosecutor. All right, let me just set up our discussion, then I'll turn it over to our panelists for their thoughts and commentary. The law here is the Fourth Amendment. It prohibits unreasonable searches and seizures, which usually means that the police have to have either probable cause or a warrant before conducting a search of a home or a vehicle. In the case that I think we're primarily going to look at, Florida against Hardinas, this is on the Supreme Court's docket for the October 2012 term. They granted cert this year, and it was too late in the year to hear it this year. They're going to hear it, I believe, in the fall. The question presented in Hardinas is whether a dog sniff by a trained narcotics dog at the front door of a suspected marijuana grow house is a Fourth Amendment search requiring probable cause. If you're not sure what a marijuana grow house is, it is what it sounds, right? It's a place where marijuana is being grown. Very quickly, the facts: in December of 2006, Miami police received a Crime Stoppers tip that a certain house was being used to grow marijuana plants. And as a result of the tip, a police officer used a drug detection dog, Frankie, to sniff at the front door of the house. In the Florida Supreme Court, the state's highest court held that the police had to have probable cause to believe that criminal activity was afoot before using Frankie at the home, reasoning that the drug sniff by the dog qualified as a search for purposes of the Fourth Amendment. And before the U.S. Supreme Court, the state of Florida, which is challenging the ruling, argues that the state Supreme Court's decision conflicts with Supreme Court precedents holding that a dog sniff does not qualify as a Fourth Amendment search. And in particular, the state cites the U.S. Supreme Court's 2005 decision in Illinois against Caballes. Another case in which we may talk about some is Florida against Harris, which the court is also going to be looking at next year. And the question here is whether an alert by a trained narcotics detection dog, whether or not named Frankie, suffices to establish probable cause to search a vehicle. Right? So you've got drug sniffs at the front doorstep of a house. You have drug sniffs that might or might not establish probable cause to search a car. And without further ado, I will turn it over to our panelists.
Thank you for inviting me to speak today. I want to tell you that after we have the main discussion during the question and answer period, if you would like to ask me any questions about the FBI undercover work or any related topics that are within my areas of expertise, I'd be happy to answer your questions. So today we're talking about these two really fascinating drug sniff cases. I'm going to mention Harris first briefly, and then I'll talk about Hardinas. the crux of the issue in Harris is really about reliability of a witness. And in this case, you have a dog. So whether you would need for that dog, the detection dog, to be not just trained and certified, but also to provide other information about the dog's experience on the job, its stats, etc. So the issue really is training and certification, proper training and certification enough? And I think it is. That search did provide probable cause, and it was a good search. So the facts were that you have a lawful stop, a lawful traffic stop. The officer saw the vehicle that it had expired registration plates, and he pulled the vehicle over. And so it was lawfully stopped. And it's like the Caballes case where during this lawful stop, during the brief stop, there was a drug detection dog in the area. And so this dog, Aldo, went around the car and alerted to the driver's side handle, the door handle of the vehicle. So when you think about reliability of a witness, in this case the dog, one thing I'll tell you is if you've worked in law enforcement, you will learn, if you've been around canines, you've been around informants, that a lot of times a well-trained and certified canine is much more reliable than an informant. So you may be surprised to hear that, but it is true. Informants have a lot of interesting motivations. And when I was an FBI agent, I led my squad in recruiting and managing informants. And when you think about whether you're going to recruit an informant or any witness for that matter, is you want to think about what sort of information that witness can provide to you. And you want to think about whether the information is going to be valid or whether the individual or thing like the dog might provide disinformation and other problems relating to this witness. So if you're a defense attorney and you're trying to attack the reliability of a dog or a witness, you're going to go after, what other motivations this witness might have had for providing the information, in this case, the alert. So defense attorneys sometimes say, law enforcement officers get their dogs to alert on purpose because they want to have probable cause for a search. Or they say that the dogs, they alert because they want to get lots of treats, because the defense attorneys erroneously think that whenever the dog alerts, it gets a treat. Well, that's not the case if you're properly handling the dog. They also will complain about residual smells and ambient odors, which we'll get into in a few minutes. So training and certification, if the dog is properly trained, there are different things you can do to avoid the problem of false alerts. One of those things is that someone other than the dog's handler during the training exercise will place the contraband that the dog needs to find. So that way the handler doesn't know where the contraband is, and the dog doesn't know where the contraband is until the dog sniffs for it. And that way the handler cannot cue the dog. Okay, so that's one way of getting around the problem. And then obviously you do not want to reward the dog unless the dog has actually alerted to contraband that is, there. Now, regarding the issue about the odors, let's delve deeper into the case facts here. So Harris, when the vehicle was pulled over, when the vehicle was stopped, was acting very suspicious. Harris, in short, was acting like a tweaker, speaking fast, sweating, acting all jittery, acting like someone who was a meth addict. And Harris, in fact, allegedly and admittedly, is a meth addict. And so the officer already had, a lawful reason to stop the car, and then already had, a suspicion that this individual was up to no good before the dog did alert. The dog alerted to the door handle. Well, why could that be a problem? Well, once the dog alerted to the door handle, because the dog smelled the odor of contraband, and the odor was strongest, the source was the door handle, The dog, of course, was outside of the vehicle. Then you had the probable cause for a search. The search happened, and there wasn't actual methamphetamine found in the vehicle, but you found, officer found epinephrine, matchstick heads, thousands of them, other chemicals that are used to make meth, because Harris wasn't just a tweaker. Harris is also someone who cooked meth and admitted after Miranda warnings that he had to use meth at least every couple days. I suspect it was probably more like daily. But when you look at the case and all the facts together, you can realize this actually is a good search. The officers did exactly what they were supposed to do, and the dog did exactly what it was supposed to do. The dog smelled the odor of meth. The dog alerted, and that provided the probable cause for a search. If you look at Supreme Court precedent, you can see that in this sort of a case, there is no reason why you shouldn't consider this as good probable cause. Do analogy to a warrant. If you're thinking about a suppression hearing, at a suppression hearing, the warrant is presumed to be valid. So what the defense then does is tries to attack the validity of the warrant. Here, you could say, all right, the training, proper training and certification of the dog, that is presumed that the dog's testimony, well, it's not testimony, but the dog's alert is valid. And then at the suppression hearing, that's the proper time to attack the witness, the dog's reliability for the alert. That's what should happen. You do not need a warrant before you have a dog circle a car, and if the dog does alert, that is probable cause. Moving on to the other case, Jardinez. In that case, you have an even more experienced drug detection dog. It was a chocolate nab named Frankie. And Frankie, at the time of the case, had already participated in over 600 incidents of having to alert. And in those cases, more than 300 times, almost 400 times, Frankie did detect contraband, and at each time Frankie detected contraband, they found contraband, the law enforcement officers did. Frankie was trained to detect methamphetamine, marijuana, heroin, cocaine, lots of different drugs. So the issue we have with the Jardinez case isn't about Frankie's training and experience. It's not whether Frankie should be certified. The issue is whether what happened in that situation was a search under the Fourth Amendment, whether there should have been a warrant. No, there shouldn't have been. Okay, first of all, the dog was not brought around the perimeter of the house, poking into private areas. The dog just went up onto the front porch and sniffed outside the front door. Now, if you think using good common sense, you realize that's not a trespass. That is not a private area that a person couldn't go to. Mail carriers, delivery people, people who are trying to sell you things door to door, they can come to your front door and knock on the door, for instance, to try to speak to you. Law enforcement officers don't have to have a warrant to do what's called a knock and talk. They can walk up to a citizen's door, knock on the door, and speak to the person as part of community policing, or to ask questions, for instance, related to a possible criminal investigation or some other event. So the act of bringing the dog up that front porch outside of the house and doing the brief sniff, that is not something that should be considered a search under the Fourth Amendment. There's another reason why it's even more ridiculous that the evidence was suppressed at the trial court level. That is that after Frankie, this really good drug detection dog, alerted, and Frankie's handler, Frankie, left, just a split second later after the dog left the porch, another officer who was one of the main officers on the scene went up to the porch, went outside the door, and smelled the odor of marijuana without even being in the house because there were so many plants being grown in the house. Okay, so you could argue that there was an independent source, and you could also argue inevitable discovery. So that's another reason why the evidence should have gotten in. But here, it's an interesting case. You had an anonymous tip that started the ball rolling. And if remember, I talked about informants earlier, that if you have a known informant, and if that informant is known to be trustworthy because they've provided reliable information in the past, an informant's tip with the other information, like the fact that the air conditioner at this house kept running continuously because it was obviously very hot inside, information like that, that might be probable cause. That might be enough to get you a search warrant, forgetting about the officer smelling the water, forgetting about the dog. But here it was an anonymous tip, so you don't have any indicia of reliability. You don't know why this person called, whether it's someone who's a neighbor who just hates this person because they don't mow their lawn the right way, or if some ex-girlfriend or ex-employee that has a grudge. So you can't really credit that informant's tip with much, but it was enough for the police to get suspicious. Now, another issue that came up in the case is public embarrassment. Okay. The Florida Supreme Court seemed to be making up some kind of new rule, like the public embarrassment rule, where if you have law enforcement officers outside of a home, they're trying to differentiate that from some other place, and that the neighbors might see, and they might realize, oh, there must be criminal activity afoot, and that would cause public embarrassment. And therefore, you must have a warrant. Well, there's no law that says you have to have a warrant just because law enforcement officers are going to be outside someone's house. That's wrong. That's not the law. And in fact, it's ridiculous. There are many reasons why you had to have officers besides just the dog handler and, Frankie, the dog that did the sniff, and then the other officer who was there who went and got the warrant. And there are many reasons why officers had to stay on the scene while the officer procured the warrant. One is for officer safety. Another is for the safety of bystanders like the neighbors. Another is to prevent the destruction of evidence or evidence being moved somewhere else. And another reason is to prevent someone from fleeing the scene. So in this case, you did have some officers who held the perimeter, and some of those were DEA agents, some of those were Miami-Dade police. Well, guess what happened? Yardinas tried to sneak out the back door of the house, and a DEA agent caught him. So that's, as I mentioned to you, securing the perimeter, making sure no one leaves. That's another good reason for having someone there. For all we know, if they had all left and nobody was there, the individual, he was inside the house when the dog alerted. He didn't come to the door, pretending not to be there. But I suspect he would have done something to get rid of those plants if he could have, or destroyed them, or besides running away. So when you have a public interest in protecting society and fighting crime, law enforcement officers have to do what they need to do within the parameters of the Constitution. And there was no constitutional violation here. The drug sniff by the dog, there was no warrant needed. They shouldn't have to have a warrant in that situation.
Thank you very much, Professor Hilton. We'll hear now from Professor Griffin.
So I'm really glad that you focused so much on the facts, and also that you had your law enforcement hat so firmly on, because you wear a lot of different ones and are an incredibly intriguing person, also an extremely unlikely undercover drug dealer. I'm guessing that you dress differently.
Very differently.
But so I think that my perspective in many different meanings and senses of that word is different, but it gives me an opportunity to talk about the law and what this portends for future Fourth Amendment cases, and why these cases are important even though the facts are compelling and yet simple. I'm going to say three things about the Jardines case, which I think are really important. The first is the way in which it is bookending the term that began with the Jones case. And why it might have something to do with Jones, even though on the surface there's nothing apparent. And that is because the Jones case, as most of you know, is a case in which the court held that the physical attachment of a GPS device to a private vehicle amounted to a search when that device was transmitting information to law enforcement about the whereabouts of that vehicle over a 4-week period. And what's interesting about the decision is that it produced a split decision, a lot of great language from the court. Justice Sotomayor's decision, which I think is one to watch for future applications of what's called the knowing exposure concept, which is really important in the Fourth Amendment, not necessarily presented in the dog sniff cases. Justice Scalia's opinion, which harkens back to a trespass or property-based conception of the Fourth Amendment and then Justice Alito's, for him, unusually, I guess, quip-filled critique of Justice Scalia's position, but agreeing with him on the outcome. So the interesting thing about Justice Scalia's opinion, which is the opinion for the majority in Jones, is this idea that trespass is suddenly much more important. You know, one time Fourth Amendment decisions turned on property, on places, on the physics of the encounters that citizens were having with law enforcement. And many of you have taken criminal procedure or taking it now. You know how important the Katz case was, in which the court announced that the Fourth Amendment protects people and not just places, and held that the attachment of a wiretap, a very rudimentary wiretap device to the outside of a public phone booth constituted a search, even though it was in an unassailably public place. So Jones, to some observers, view Jones as taking us back to this conception of trespass and reasserting in particular, the threshold of the home as the firm line that the Fourth Amendment will not permit law enforcement to cross in the absence of a search warrant issued by a neutral magistrate. And that's one way of reading the case, and Justice Scalia was able to resolve the case relying on those principles because he honed in on the fact that the GPS device used was physically attached to the car. Of course, that begs a host of questions because in most cases, all you would have to do is flip a switch and you would be able to track GPS. So he relied on some facts that were, in some respects, a one-off for that case. But even if you view it as a case about trespass, which I think is a very reductive view of it, it cuts both ways for the dog sniff case, for Hardinez anyway. So on the one hand, it is certainly true that, as Professor Hilton points out, a dog standing right outside the front door, or a law enforcement officer standing outside the front door, or the FedEx guy standing outside the front door, those are not trespasses. They are trespasses if they start to walk around the house, go into the backyard, begin to poke around in more intrusive ways. But it's well established that the front door itself and standing in front of it wouldn't constitute trespass so long as the threshold, and this is observed in a very formalistic way, the threshold is not crossed. So in that sense, you get the argument that the firm line is at the threshold, the dog didn't cross the threshold, and so trespass resolves the case. The other problem, though, is that in order to get the votes necessary to resolve the Jones case, there is a reassertion of the Katz formula and concept in it, which is that the Fourth Amendment protects against governmental intrusions into reasonable expectations of privacy. And what Jones necessarily says is that if you have a trespass, it's an easy Fourth Amendment case. If you don't, it's a somewhat harder one. But you still have to make those inquiries into whether there's been a search in this more amorphous sense of an intrusion into privacy. So I think it cuts both ways in this case, and it'll be interesting to see how the court gives Jones expression in applying it here, because it'll help us understand more about what's going on with those separate opinions. The second sort of global Fourth Amendment jurisprudential thing that I think is implicated in this case is this notion that underlies a lot of Fourth Amendment discussions but doesn't have a real doctrinal hook and therefore is sometimes hard to identify. But there is this strong idea with a long provenance that the means matter in the Fourth Amendment, that it is not just an ends-based doctrine, and that it has a lot to do with the experience of the intrusion in question. And here I think that your question about what's the deal with the public embarrassment, I don't at all doubt any of the things that you say about the law enforcement imperatives. Of course, I mean, that was textbook in many ways. That's decidedly true. But I think the reason for the Florida court, erroneously or not, to have focused on this is that they're picking up on the cadence of this idea that how bad the experience is for the object of the search actually is relevant to the reasonableness of it and to the assessment of it. For those who may doubt that, the classic example is that the court has held that helicopter and airplane overflights from the same altitude and seeing the same thing do not come out the same way under the Fourth Amendment. And in doing so, they talked about the noise, dust, and intrusion into the enjoyment of property that the helicopter at the same altitude, but that the experience of having a helicopter hover over you is more frightening and more intrusive than having a glider plane, say, or some other plane go over at the same lawful altitude. So it's not just about what you can see or what you can smell if you're a dog. It's about the difference between being in an airport and understanding that when you're in the airport that they're using backscatter x-rays, that they've got dogs, that you're going to be asked questions, and understanding that you're having that experience and that you're going to have that intrusion and the fear that might result from being in that situation, and having a dog at your front door. So I don't know if this is a case where the court will give that any expression, but there is an invitation from the Florida court to engage with that because of this discussion of what it was like. Of course, that cuts both ways too, because the dog only needs to be briefly there, can actually do this without the knowledge of the resident of the house, and isn't nearly gathering as much information as a GPS device, for example. Which brings me to the third, I think probably most critically important issue about this case and why it matters so much, which is this contraband-specific argument. The beauty of this case is that despite the aspiration of a brave new world of law enforcement, there really isn't any device as sophisticated as this very low-tech dog when it comes to an up or down determination of whether there is, in fact, contraband. But law enforcement is always working on this, and you would know more about this than I would, but they are beta testing devices that law enforcement can wear that will give signals when they are encountering people who are carrying weapons, concealed weapons. There are all kinds of technologies that are used, in the airport setting, for example, that are very high tech. There's the classic hypothetical, which will surely be discussed in the case of a mechanical dog, a device that could broadly cover a whole neighborhood and pinpoint houses where there might be contraband in that neighborhood. So the argument about the dog being contraband specific will be very interesting in terms of what the limits of that concept are and how far the court is willing to take that, and also in terms of how perfect the technology would have to be in terms of its contraband specificity. So dogs are better than anything else, but they're not perfect. There's a discussion in Justice Souter's separate opinion in Cabayas from 2005 about the myth of the infallibility of the drug-sniffing dog, and he's right about that. They are not right all the time. The question is whether that matters at all. So that brings me to Harris, which is a case really about, so let's assume that each of these issues is resolved in such a way that the dog sniff itself doesn't constitute a search. The upshot of that is that law enforcement now has enough information to get probable cause and can go and get a warrant and conduct a full search. And the Harris case raises the question of, is a dog sniff enough for probable cause? And it is, like the Jardines case, a perfectly distilled version of a very, very difficult issue, which is how much probable cause do you need to call it probable? And the court has avoided forever putting any percentage determination on that, deciding any case that would compel it to even articulate a range within which you would view it as probable. Is it 51%? Is it 82%? One law enforcement officer's view of that is different from another's. It's an extremely slippery concept evaluated under a totality of the circumstances inquiry. There are a few things murkier in criminal procedure, but they took the Harris case and they took it in this way that perfectly serves up the question. The litigation about probable cause and whether it's been met as a standard, almost all is about informants. So I think it's very interesting that you raise certainly dogs are more reliable than informants. I don't think that that's in any way unpersuasive. But what the court has had to deal with is, how reliable do informants have to be? How much corroboration does there have to be? How well does law enforcement have to know them? How long-term does the relationship have to be? Anonymous tips are not enough, and we know that. But when you start layering things on top of anonymous tips, then all of a sudden there are real questions about what the quantity of cause you would need would be, and whether you can get it from certain kinds of informant information that they pass on. So the dog helps us to answer that question in this very distilled way, except that the dogs aren't perfect either. So when they're good, but they're not perfect. I'm going to have to retire this story because some of you have already heard it, and I'm going to tell it now for one last time, a little swan song. So when about 2 weeks on the job as a federal prosecutor and extremely eager, I was approached by some DEA agents who wanted to do a search of a storage locker in Chicago. It is, as you know, very common for organized drug trafficking organizations to put things in storage lockers because you can sign up for those things with false IDs. It's completely easy. There's zero information about who you are leading back to you. You put all your stuff in there, you lock it up, and then when you need to get to, it's a better stash house than a place where you have to sign a lease. They're commonly used as stash houses. And this dog, they had a tip, anonymous tip, about the storage facility, like a public storage facility, and they walked up and down the aisles, and a dog alerted on one particular locker. And I wish I could remember the name of this dog, but I want to say it's Briscoe or something. All the dogs in Chicago were named Briscoe or Roscoe or Romeo or Bravo. I guess in Florida they're named Frankie. But like every dog has a name like that. And they even had baseball trading cards for all the dogs and would give them out. You may remember the tradition that if you won a trial, you would get, like a law enforcement, you get a search warrant, you get a little dog trading card. And they have their stats. So they actually have stats, just like batting averages. And, 70%, 80% hit rate, some of them great, in the 90s, some of them getting down to the 60s and facing retirement. But they do have stats. I mean, they are not infallible, and Justice Souter's quite right about this. So this particular dog had decent stats until this day. And we got a search warrant, and we had the probable cause, better than an informant, and beyond anything that had ever been litigated about what probable cause constituted. And the entire storage locker was filled floor to ceiling with tortilla chips. Floor to ceiling, inexplicably. Boxes of restaurant size, huge, those big bags, like from a strip mall Mexican restaurant type tortilla chip, in these gigantic cardboard boxes.
Any
Nothing,
salsa?
No salsa. A lot. I got that from a lot of colleagues that day. Not that good though. Good.
Sounds like a sensible dog to me.
Okay. Well, so the joke was that the dog just alerted on the tortilla chips. Now, of course, there's better explanations for that. One is probably it was a storage locker that had been used to store narcotics, and they're alerting on the residual scent of that. The other is that a lot of times drug traffickers use dog treats and tortilla chips and other things to package their narcotics in the hopes that a dog will alert. If a dog alerts, someone will look at it and go, no, the dog's alerting because it's dog treats, which any good handler would know is not what the dog is alerting on. But that is a common technique. But they went through, went through the whole storage locker. Nothing in there, went all the way through to the middle, nothing but tortilla chips. Ridiculous scene now. I didn't physically see it, but I saw the pictures. Ridiculous scene, tortilla chips everywhere, cardboard, and all they can do is leave the search warrant, we've been here, thank you very much, Chicago DEA, close the thing up, lock it, and walk away from this scene. And, I don't think anyone ever came back or ever intended to for the tortilla chips, but the dog wasn't perfect. And I don't know if that dog, I doubt very much that dog worked much after that day. But I don't really know that it's the dog's fault necessarily. There's a Dennis Miller joke that's been going around since the grant in this case that some of you have probably heard. I didn't see it live, but it's been repeated to me many times. Do you think the dogs have some sort of lottery about which ones are going to sniff for explosives and which ones are going to sniff for drugs? You wouldn't. Okay, you wouldn't want to be the dog. You wouldn't want to be the dog that sniffs for explosives. The point of all this is that both of these cases test the court's commitments to some concepts that have long-standing usage, but the limits of which are exposed by the simplicity of the dog sniff cases. And they're going to have to think about, is it that you don't have a privacy interest in contraband? Or is it that if there's a technology that is only alerting to your contraband, that there hasn't been a deep intrusion? And the answer to that matters a lot. And they have to look at whether the likelihood of finding non-contraband items, which is a thing that the court has never fully articulated, because the Fourth Amendment is never evaluated ex post in terms of what you found. It's evaluated ex ante in terms of what you knew when you went looking. And when these cases get litigated, something was always found. But the problem of the non-contraband item that is turned up, or the person who's carrying the tortilla chips instead, might have to be confronted by the court. And that's the host of issues raised in a single short question presented.
All right, well, thank you very much, Professor Griffin. We have a good 25 minutes for questions and discussion. And I'm happy to get us started, but I would love to hear from you folks as well. So one question about the facts is, what does it mean to be properly trained or certified? It sounds like there's agreement that an improperly trained and uncertified dog doesn't establish probable cause, right? And it sounds like a dog that, there are false negatives and there are false positives, right? 60% sounds a lot worse than 90% in terms of accuracy. 30% sounds pretty bad, right? So, is it the role of the court to establish a certain threshold of accuracy before the court says this is going to suffice to establish probable cause? Or is it enough that it's gone through the training and certification procedure no matter how poorly it's performed in practice, right? And I'm assuming that dogs, like people, right, vary in the extent to which they do their jobs well. The legal question I'm wondering about is if the government wins in Hardiness, and if it's not a trespass to do a knock and talk, does that just mean the police, as a routine manner, can go around with drug detection dogs, walk up to houses, knock on the door, and see if a dog alerts, right? Is that permissible? And then if that's permissible, what about the technology that just from the police station you can just cover the entire neighborhood, right? You have this sort of the equivalent of the mechanical dog, right? So are there much broader implications than just the facts of these cases might suggest? So answer either, answer neither, whatever you, either of you prefer.
Well, I think there are a lot broader implications, certainly with the advances in technology. I'm glad you mentioned Jones. It made me think about some other cases as well. You can analogize to a few other types of opportunities that law enforcement use to get information about people. One of those is putting telephone type poles or poles near a residence and then putting a camera, mounting a camera on a pole. You may be surprised to know you don't need to have a warrant to do that. Also, for a PIN register, to get the telephone call information, not to actually listen to the conversations, but to get the phone numbers that are dialed, and then to get the numbers of the incoming calls that go into someone's phone. You don't have to have a warrant for that either. And it could be argued that poll cameras and PIN registers are more intrusive than having a drug sniffing dog just very briefly on someone's front porch and then the dog leaves afterwards. So if you look at other cases that involve privacy interests, there are some interesting, analogies, and I think that it's really possible that some of those other types of non-searches will be revisited in the near future, and that people will start thinking about what's permissible. You look at the Kylo case also, with the use of thermal imagers. That was also a grow house type case. Those are sort of the opposite of the dog. The dog is the low-tech detector, and the thermal imager is the high-tech detector. And with the thermal imager, you're looking for heat. You're looking to see if there's a lot of heat coming out of a roof of a home or other areas to try to figure out if it's being used as a grow house, because when you have a grow house, you have all the lights, you have heat from hydroponics. And with the problem with thermal imagers, as you learn if you read the Kylo case, is that you get a lot of information that isn't just related to contraband. You can find out, for instance, what time of day the lady of the house uses her sauna and has a bath or a shower. Obviously, bathing is not related to drug use unless you're maybe smoking a joint in your bathtub. But the dog is just going to be giving you information about the presence or absence of contraband. And so those are interesting analogies with privacy. Yeah, you have a question?
Yeah, I was curious if it's just about contraband, what would prevent police officers from, say, taking a drug dog into the lobby of a college dorm, and the dog alerts? Does that then open the whole dorm up to the police officers? Do they have probable cause to search?
What are you worried about? What are you worried about, Katie?
I don't live in a dorm anymore, so nothing.
but there's the DLJ office too.
I know.
I'll say I'll say a few words about how these dogs work, because I think maybe there's a little misunderstanding about how the dogs work. First of all, canine units, the dogs have specific jobs. Some of them are sole purpose dogs. You know, they do one thing and only one thing, like for instance, try to find, detect contraband, like narcotics. Other dogs may work as dual-purpose dogs, apprehension and detecting drugs. And some dogs work, for instance, with evidence response teams. Like I know someone who's a female FBI agent, and she has a German Shepherd that is a canine, and she's with the ERT in New York, and her dog and her, they both work at scenes where they're looking for cadavers, they're looking for bodies. So her dog is a dual-purpose dog, and then it looks for bodies, and it also looks for materials that could be linked to explosives, explosive residue. So these dogs, when they detect an odor, it's kind of like an invisible cloud. We don't see it, but the dog smells it. And so when the dog detects the odor, the dog moves around. It generally goes back and forth, sniffing the odor cloud, pinpointing the source. So it's not as if the dog gets confused or anything. If the dog's a good dog and well-trained and has a good nose, it doesn't think, oh, there's odor somewhere here in this college dorm. If the dog detects the odor, the dog's going to move back and forth until it finds the strongest source of the odor. And then the dog is generally going to sit if the odor is coming from low down, like in the Jardinez case where it was marijuana, the strongest source of the odor was coming from underneath the door, or if it's high up, it'll go high up. But the dog won't just give it a general alert. The dog gives a more specific alert to the source. So there have been cases involving, interesting you mentioned dorms, there have been cases involving places that are residents that are not private homes, that have been apartments, and most of the time the courts have come to the same conclusion where they think that the dog sniff itself is enough for probable cause, and then you could get a warrant, that you don't need to have a warrant to have the dog do the sniff, especially if you're thinking in terms of a hallway in an apartment building. That is not a private area that only one person can go into, the resident of the apartment. Obviously other people have to go into the hallway to access it, to go to their apartments or to do deliveries. So that's how that comes up in the non-private residence cases.
The dorm issue and the kind of hypothetical robot dog or the machine that can broadly detect all sorts of contraband raises because your question in particular raises a possibility that the court might want to engage with what's sometimes called the proportionality question. Historically, the court has not wanted to engage with that, and they don't need it to resolve either one of these cases, so I would be surprised if they did, but my capacity for being surprised at the court expands daily. So who knows? The proportionality question basically would be, they would need, they don't already have probable cause, which they wouldn't have, or they would just go get the warrant to begin with. They can't do this sort of intermediate step of bringing in the dog unless they can at least get reasonable suspicion or some such standard. So that's proportional. In other words, the dog is somewhat intrusive, but not as intrusive as kicking down the door and searching the dorm room. But you're not going to be there with the dog and subject everyone to that unless you can have a reason for being there. Arguably, in this case, the anonymous tip and the air conditioning unit might meet some lower Fourth Amendment standard than probable cause, even though it's not enough for probable cause. So there's kind of a backstop argument that there's proportionality here, that they did what they were supposed to do, that they used the dog because they had this preliminary suspicion, it wasn't enough for probable cause, but then they went back and they're going to go back and get a warrant from a neutral magistrate. So that's possible. So the answer to that would be that to the extent that the technology becomes available that can so broadly detect contraband, the classic response to that is, well, okay, but we would only want that happening if we knew that there was a bomb in some 10-block radius. We already had information, not just hypothetical trolling for it. But that's not the actual doctrine, so that would have to be invented. And that would be interesting to see if the court wants to invent that too. The other issue that your response raised for me is just understanding how this idea about, you said something about the invisible cloud, and it reminded me of this idea that I think the court is so far behind on understanding, the cloud itself, that what the cloud means to all of you. All the spectrum, it's a little bit of a slide that, the nature of the intrusion is on a sort of spectrum, so it's very hard to quantify it in any specific way. But, if you view Kylo as, an endpoint where it's not particularly intrusive, but the court has said that that is a search using that sort of thermal imaging, and something like, just overhearing a conversation on the other end, that entire spectrum, the actual spectrum itself is formed from this idea of a residence or a home. And it may be that the future spectrum is not about grow lights, but the cloud itself, and that is the place where intimate activity is taking place in the future, where the volume of information that we would truly view as too intrusive for someone to look at exists and is in some space that law enforcement could access but needs justification and approval to do. So the actual spectrum may be changing in a way that the court hasn't dealt with yet.
Yeah, so your comment about residence, I think, highlights what I saw as one of the interesting differences between these two cases, which otherwise seem to have a lot of similarities, which is that one of them involves a car and one of them involves a home. And as I know from my excellent criminal procedure professor, there are a lot of unique rules that deal with cars and unique rules that deal with homes. And I was wondering if you could, either of you, I guess, could comment on what you see as any potential areas by which the court could use that different jurisprudence, and specifically things like Kelo, where you don't have intrusion but you do have invasion of a protected space, where you might not in the case of a car. I don't think there's been a case where you would use IR against a car. I don't know, find a body in a trunk or something, but I could see, that would be less of an intrusion perhaps. And I was wondering if you could talk about how the difference there might impact the court's decision.
Well, I think that the distinction between public and private and things like the home and other things like the car, with our advances in technology, has become more fluid. People are doing more and more things outside the home that they used to do in the home. When you think about working remotely from cafes, and you're doing some things that were totally in private, and now people can see what you're doing more. On the other hand, sometimes people are working from home rather than being at the office. So I think that, yes, the home is still the castle, the home is still private, but with all the advances in technology, with how easily you can get information about someone over the internet with Facebook, and people putting more and more information out there that everyone can see, putting photos of themselves and their friends, and intimate activity and friending people, is the lines between what is private and what is public and what is secret and what is not are kind of blurring. And one of the things you think about with privacy in cats is whether someone has a reasonable expectation of privacy and whether society would agree that that information should be private. So that's one way I think the law is evolving, and things can be a little bit more confusing for judges and for the public and for law enforcement.
Other questions?
So talking about the dog sniffing the door sill, if a police officer was to lie down on the ground and sniff a door sill, would that be okay?
Well, as a matter of fact, the police officer didn't have to do that.
What if it did?
Yeah, I mean, it seems a little ridiculous for the police officer to lie down, but I guess technically it's a public area, the front porch. It's not a trespass to come up to someone's door and to knock on the door to try to talk to the resident. And the officer who was on the scene, who walked up the porch right after the dog handler, did smell the marijuana plants because the smell was so strong. But let's just say hypothetically the case was different and the officer was lying down on the ground, I think that would still be permissible. But here you had an officer who smelled it himself with his non-canine, very primitive human nose. And so you could say that the information about the marijuana shouldn't have been suppressed at the trial court level because of inevitable discovery or because of the alternative source doctrine, because the cop, not just the dog, but the cop smelled it, regardless of the dog, even if there hadn't been the dog, that the cop, if when he came up to the door, he smelled it.
I mean, it does sound to me, from what you've been saying, is that although the facts of this case seem really, really great, right, for the police. But if you say if there's no Crime Stoppers tip, and if there's no smell that's discernible by a human, and the police as a routine manner were just deploying officers with properly trained and certified drug detection dogs and showing up at every front door and knocking, I mean, that's all within the scope of the 14th Amendment, and of the Fourth Amendment, and if any of them alert, that's probable cause to get a warrant. Now,
I actually would have a problem with that sort of behavior.
But yeah,
You
well,
know.
but
I don't
as
think
a
law
pub-
enforcement has the resources to do that, first of all, but I would find that very George Orwellian, you know, and.
Right, so then the
I have a
question
problem with
is,
that.
what kind of constitutional resources are there, intrinsic or extrinsic to the Fourth Amendment, to put a limit on it, right? What's the limiting principle, as we've been hearing a lot about over the last week in the context of healthcare, right? But I do think, and then when you talk about the mechanical dog, right, who I will name Archie, right, I think it's even more, right, it becomes more disturbing. So you can see how, right, the court takes cases to make law for a whole variety of fact scenarios, not just the one before the court.
Kara,
Okay.
did you have a question?
Yeah, I did actually. Well, so if you brought it up when you were talking about public versus private and the way that the nature of our society is evolving, but that's one of the questions that was theoretically raised by U.S. v. Jones, which was not addressed by the court because they decided it pretty narrowly.
It's in Sotomayor's,
What?
it's in Sotomayor's opinion, though.
Not
Not that you can
but
do
again, that was
anything with
not
that, but it's there.
right. It is there, but it was not engaged with by the majority. So my question kind of is: this is the kind of case which has simple, seemingly facts, but that raise issues regarding the limits of the principle, and like Professor Siegel was just saying. So, but my worry is that the court isn't going to choose, like they haven't chosen to engage with the proportionality arguments, that they're not going to choose to engage with kind of the larger issues raised by cases like this. And I kind of was just wondering what you think the likelihood is that they will kind of look at this case as an opportunity to look at the limits of the principle, or if they will look at this case to decide the more narrow issue of, you know, can a dog sit down at the threshold of someone's home because it smells marijuana?
I think that depends a great deal on what happens in the next few months. It's an incredibly interesting institutional and cultural moment at the court right now. You could use words other than interesting, but I'll stick with that one. But there's something going on that transcends, I think, even the Affordable Care Act litigation. There's something that I would love to talk to you about, because you would know much more about it than I do. But in the strip search case, which took them a really long time to decide, and then there are these separate dissents, including Chief Justice Roberts' statement that the court needs to be careful with these decisions so they don't embarrass the future. Which is an old line, but incredibly apt. And so the answer to your question, I think, depends on how much they're thinking about that when they decide these cases. Because they will engage with so if they say contraband specific, you're fine to law enforcement, then that means that in the future, when the brave new world of law enforcement comes and regular workaday cops can use and wear devices that are mechanical that give them indications of who's carrying weapons and who's using narcotics, that they have to confront that. And maybe that would be embarrassing in the way meant by that line in the opinion. So it depends on whether they want to deal with that. The same is true of the Harris case. If they want to quantify probable cause, then they have to deal with, this cuts the other way, with the impact that is going to have on the discretion that law enforcement exercises. And there may come a case that is equally embarrassing on the other side, because they've hamstrung that. So I really think it depends on how mindful they are of that principle and what they think it means.
How much is, I don't know a whole lot about it, but how much is reliability kind of a part of the Fourth Amendment jurisprudence? Because it seems like what makes Frankie a great dog for, plausibility, probable cause, is what makes him kind of intrusive, is the fact that he can gather so much information. So is that something that's kind of a part of the discussion in the Fourth Amendment?
No. It is something that is a part of the discussion. So the reliability issue is deeply important to the determination of probable cause, but it's what the dog actually finds in the search in question is not supposed to matter with respect to whether it was a good search in an individual case. And that's because the aspiration of the Fourth Amendment is to interpose some ex ante assessment of whether it is worth making the intrusion because of what you are likely to find. But whether or not that was a good decision is not assessed according to what you find itself.
Well, I guess it's just like how effective the dog is in terms of finding information is, I mean, kind of with machines, kind of what bothers me about that is
that how much information can be gained by police officers is kind of the concern, but that's exactly what would make it a good technique for finding probable cause. And so it seems like almost the two kind of conflict in terms of what we want for probable cause is what maybe we don't want for Fourth Amendment. Is that?
I think that the more, if by what you mean by that is that something that is an incredibly effective information gathering technique, like a wiretap, which is picking up all kinds of information from your conversations, that is both a great investigative technique and an incredibly deep intrusion into your privacy. And so that, in determining whether or not you would have what you need, which actually is more than just probable cause, is statutory overlay on the Fourth Amendment in Article 3, to get a wiretap, you are accounting for how much information you can access. But what you don't do is look at it ex post and say, well, we heard all this stuff about this argument between spouses and all this other intimate stuff that was totally relevant to our case, but we also found out about the hit that this organized crime group was putting on someone. I mean, you would never make that analysis. But ex ante, you're going to ask, how deep is this intrusion? And that's actually why the contraband-specific nature of the dog is so relevant.
Right, so do dogs alert to things that people do have a reasonable expectation of privacy in?
That's the question. That's the course. So a lot the course.
Are you my therapist?
The courts, they like to say, but the flip is that the court likes to say, well, you don't have a legitimate expectation of privacy in contraband.
That's what. Yeah,
that's
that's what
way
I'm saying.
too easy. Because what they really mean is that the intrusion isn't unreasonable because all it's getting at is contraband, which is not exactly the same thing. And there's slippage in lots of decisions as between those two concepts, and resolving that is what it will take to get to the bottom of this case.
These issues are also becoming more complex as marijuana is made legal for people who have medical marijuana, for instance, because let's just say, for instance, an individual is being treated for cancer and has not told his employer about the cancer, because of fear of discrimination on the job, but the doctor has given this person a prescription for medical marijuana, the guy's smoking it at his home. For some reason, some person who hates him, phones in an anonymous tip, drug dog comes, and you find out about, yes, indeed, this guy has a pound of marijuana in his closet, and some plants, for personal use, and all of a sudden, you find out about the cancer too. So things like that are going to be rather interesting because, in my example, the hypothetical I just gave, this guy was legally using, he's in a state where it's legal, let's just say the guy's in California, he has a prescription. But now you have some very private information about his illness that's coming public.
Or you're using a device that detects weapons and you're in Arizona and you have a license to carry a concealed weapon.
Yeah.
Anyone want to talk about federal power to regulate the personal possession and use of marijuana for medicinal purposes pursuant to state law authorizing the practice? And 6 justices who agree with that? No? Okay. I saw a question in the back. Okay, you have the last word.
Yeah, I guess a lot of the talk today has been focusing on the competency of the dogs. Well, maybe not a lot, but I'm almost more concerned about the competency of the handlers and what sort of training and continuing training they do. So I'm reading, I pulled up an article from the Chicago Tribune that talks about, a 3-year study of the use of dogs in the greater Chicago area. And
are they all named Briscoe?
Yeah, all named Briscoe.
All the names
so
you know.
Only 44% of the alerts led to the discovery of drugs or paraphernalia, but what was more interesting to me was
say that stat again?
44%.
What was more interesting to me was that for Hispanic drivers, the success rate was just 27%. So I don't know what conclusions you can draw from that, but it
I
seems
can explain that easily.
to me that
they get pulled over at a higher rate.
What's that?
They get pulled over at a higher rate
Right.
with
It seems
less
to me that
suspicion behind that decision. That's well documented.
Yeah.
So this is true of every kind of contraband and every kind of the hit rate on traffic stops for all kinds of minorities is much lower than the hit rate on Caucasians. And that's because usually when a Caucasian is pulled over, the law enforcement officer is acting on some reason to do it.
Yeah. So it just seems like law enforcement is engaging in practices that they shouldn't be doing, and maybe using dogs as an excuse to search cars. Maybe. So I just don't understand well, maybe I'm drawing the wrong conclusions from this, but it seems to me that cops are using dogs as an excuse to do searches, and maybe they're giving cues to the dogs to hit more often than they would in situations where, you know, if it's a white driver, then they don't give the unconscious cues. If it's a
I don't
minority
think
driver,
that's
they
what
do.
explains it.
What's that?
I honestly don't think that's what explains
Okay.
it. I think what explains it is the rate at which different sorts of drivers are pulled over to begin with. I don't think it's about the way that the handler is interacting with the dog.
But then,
I think it's about the likelihood that the person they chose to pull over who's a minority has contraband versus the likelihood that the person they choose to pull over who's a Caucasian does. Because the reasons they're pulling over the Caucasian driver are also indicators of the potential possession of contraband or other criminal activity.
okay.
I'm sorry, we can talk about that later. It's a statistical thing,
Yeah,
but
no,
there
I
are
agree.
explanations for it.
Yeah.
Well, I want to thank our panelists very much, and thank all of you for your participation.
Produced by Duke University. Online at duke.edu.